Thank you. You may be seated. Case for this afternoon is 2025-50130, the Lutheran Church versus Donald Christian et al. You may proceed with your argument.
May it please the court, Daniel Blomberg for appellant. I'd like to reserve 4 minutes for rebuttal. This appeal concerns a pure question of internal church governance. Specifically, in the polity of the Lutheran Church Missouri Synod, is LCMS responsible for defending the church's civil interests? The answer is yes. That answer has been provided by the church's designated authority on church polity. It has also been the church's practice for 130 years. And it reflects the church's two kingdoms doctrine, distinguishing the roles of church and state. Under the First Amendment, the church's answer is authoritative, and accepting it as authoritative easily confirms diversity jurisdiction here. But instead of accepting it, the district court unconstitutionally second-guessed and then replaced it. And while Concordia now abandons the district court's analysis, Concordia's new theory still depends on the exact same constitutional violation. This court should reverse that error. Whether we're talking about the real party and interest test the district court used below, the real party and controversy test that Concordia uses now, we get to the same place jurisdictionally speaking. Under Navarro and Lincoln Property, we're looking for the entity that has legal title, that manages assets, that has litigation control, that accepts responsibility for the litigation for a resulting judgment. Under the church's representations to this court, all of those things are true of LCMS. None of them are true of the Synod, not a single one. In fact, under the state court litigation that's been going on concurrent to this appeal, the Concordia seems to be conceding a lot of those points. It now admits that LCMS is not merely acting in a representative capacity, but has its own claims, and that Concordia can proceed against LCMS alone, and in fact withdrew all its discovery against the Synod.
Take judicial notice of that, or did you have anything in our appellate record about that?
We take judicial notice of it, Your Honor, and I think the key question...
It's hard to take judicial notice of things in state court records sometimes.
Correct, Your Honor. We tried to assist by providing the links to the official documents, but I think the key question is that, or the key issue isn't what Concordia's position is, the key issue is what the church's position is, but rather Concordia's position seems to have evolved over time, giving this court an opportunity to ask them about that. Under the church autonomy doctrine, the key rule is that this is a structural limitation on the power of the state that gives to religious bodies the authority to determine matters of faith, doctrine, and internal governance. And when we're talking about a matter of church polity, we're dealing with both doctrine and governance, both the church's decision on how it's going to organize itself and the religious purpose and rationale for that organization.
The district court and the magistrate judge seem to think that there is some separate thing that's the Synod that has property and that can be sued whenever, and it's not clear where that comes from.
Correct, Your Honor. That was their analysis by choosing to disregard the church's representations in court and instead choosing to review the church's own constitution, its bylaws, its policies, and substitute its own understanding of those things, which was an error.
This is not a situation where there's going to be some kind of switcheroo at the end where they say, oh, well, the Synod really has the property and you sued the wrong person all along, ha, 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 and we're going our merry way. This is not that sort of situation.
Correct, Your Honor. We have 130 years of church history. We have the church's authoritative representation. There's no attempt to pull the wool over anyone's eyes. LCMS has litigated in diversity jurisdiction a variety of cases.
When you talk about the church's authoritative representation, are you talking about Sias, that statement?
The two declarations by Reverend Sias, correct, Your Honor, the Secretary of the Synod.
Well, but when you have an entity that has a constitution, bylaws, other governance documents, doesn't that look just like the kind of civil matter that courts would have jurisdiction over?
No, Your Honor, and I think the case to look at for that is Milivojevic. when the Supreme Court dealt with exactly that sort of issue coming out of the state courts, and it said the lower courts were wrong to have gone and looked at the Constitution, because that was the argument. The argument was the Constitution says one thing and the church is saying the other, and the court is going to adopt their interpretation of the Constitution. And what the U.S. Supreme Court said is, you can't even review the Constitution. You need to accept the church's representations on its own polity without looking behind that representation to look at the Constitution. So it's very different.
The church can just declare that this is what we intend, and then the court has to accept it?
On matters of church polity, on its internal governance. And of course, with any religion claim, Your Honor, there has to be an element of sincerity, and there's opportunity to test sincerity. But there's no question that we have sincerity here. There's been no evidence to the contrary. There's no doubt. Again, we have 130 years of history on that. All that we have here is the contrary interpretation of the church's own governance documents. What the U.S. Supreme Court has said is that's impermissible. You can't do that. And again, that's in Milivojevic in 718 to 720 clearly lays that out, Your Honor.
So would we be wrong? So even if we were to say we think that the documents, the Constitution, does not accord with what the district court said, we would be wrong to do that.
That's right. That's right. And that's
We're not at liberty to. If we could simply decide this case by saying, that's not what the Constitution says, that would be a mistake.
correct. And that's exactly what the Supreme Court said in Milivojevic at 718, where it said, we need not, and under the First Amendment, we cannot question whether the church's representations of its own polity were true. And in that case, the court had said it's admitted that it's not always consistent how the church interprets or how the church's documents write. And so that's not the point. The point is that when we're dealing with a pure matter of internal church governance, that's committed to the discretion of the church alone.
Suppose one were to say that the district court erred in saying that the only real party here is the church and not the corporate representative. That's not in accord with diversity law, as long as one concedes that the corporate representative is a real party. So is it possible to avoid the entire issue?
I don't think so, Your Honor, and the reason why is that, to Chief Judge Elrod's question earlier about how we do the analysis, it's used to the district court's holding below, and my friends on the other side argument is that you have to look at the Constitution. The Constitution says all of the interest is owned by the ecclesiastical synod. None of it is owned by LCMS. And our point is that the church's representation is that's untrue, and you have to accept that in order to do the rest of the analysis. And that acceptance of the church's representation of LCMS's authority here is itself a representation, a reflection of the church autonomy doctrine.
So you're not relying on the fact that the Constitution says that LCMS, as the civil representative, actually holds the titles?
Correct, Your Honor. We think that's correct. We think that's the right interpretation of the documents.
We don't have to go to Reverend Sias for that.
You don't, Your Honor, but we think that for resolving the issue of who the proper party is under the church's polity, that it requires.
Are you asking, well, I know you want to make law, and that's my question. We're not supposed to make law if we don't have to make law.
Certainly, Your Honor.
So if all you need for diversity purposes is a party, and we can ask your opponent about what that means, but if we believe that the documents sufficiently show that this corporate synod is a real party, that's the end of it.
Right, Your Honor, but I think the issue would be that looking to the documents and looking past Reverend Sias's representations would be an error. So I think the appropriate step at this point is to look at the church's representations, which are correct, but that's where the church is. It's not a big step in the church autonomy doctrine, Your Honor. I think accepting my friend on the other side's arguments require much more significant steps, including incorporating the neutral principles approach into church governance issues, finding that you can waive a structural limitation on the power of the judiciary. Courts have never held those things. This court has repeatedly rejected them. I think there's a fairly small step that needs to be taken here, but there is a real step that has to be taken to recognize that the church has the authority in identifying its own polity.
Why are you putting things in a hierarchy of what we can look at and what we can't, though? When but we have the church representatives document, but why, in some cases, you're not going to have a church representatives document. Why does the fact that we have that document render that we can't look at the other if we're trying to decide what has the church said itself about its own polity?
You're right.
Doesn't it speak through its constitution as to what its polity is?
It does, Your Honor.
That's why this is, what case says that when there's a declaration, you can only look at the declaration and not also at the Constitution if the Constitution is also speaking for the church?
Well, I think Milivojevic goes here, Your Honor, when it talks about the issue of whether the court can interpret the Constitution when it has the authoritative representation of the church. And what the Supreme Court says, we need not look at that question, and we cannot, under the First Amendment, look at that question.
Well, I don't know that you're necessarily interpreting the Constitution. I mean, we're not trying to, if you just say the Constitution says that the corporation exists for this purpose, therefore all hands off. I mean, it seems to me it's not so different than looking at the Declaration.
Well, and to be clear, Your Honor, we think that the church should win this case without having to make a representation. We think the pleadings were sufficient on this. We think that all the documents are sufficient on it.
And you tell us we can't look at the documents, so that's the problem.
Right, Your Honor, and I think the reason why is the reason for looking at them would be to question the interpretation of the church.
Well, just to say, what is the church's interpretation?
Well, I think, and to say what is the church's interpretation would be to look at Reverend Sias's representation on that point, Your Honor.
Why can't you also look at the pleadings and the Constitution to say what has the church said its position is?
Well, I think you certainly can look at the pleadings, Your Honor. That would be consistent with accepting the church's representations. And I don't think that it doesn't mean that there isn't some level of, like, Reverend Sias says this, and he cites the Constitution there. Yeah, that sort of thing isn't problematic. But interpreting, allowing the judiciary to have final authority on a matter of church polity, to answer what the church's polity is, raises the kinds of church autonomy questions, because this is something that's devoted to the church alone, to maintain these sorts of things.
The question is not what is the church's polity, it's what has the church said its polity is? And where can I glean what the church has said that?
Right, and I think the places that you primarily should, the primary place the church autonomy doctrine would direct this court to is the declarations of John Sias and the pleadings before this court, and then that's consistent with the church's position in its constitution and
you get autonomy
bylaws.
with respect to internal management decisions that are essential to the institution's central mission. Is that right?
Yes, correct, Your Honor.
What's the internal management decision that's at issue here?
Two of them, Your Honor. One relates to the relationship of the synod, the denomination, to its member, to the congregations that are a part of it. Those are all autonomous bodies. They are not a part of an unincorporated association like the district court held. And so it changes the church's polity by making them all one legal entity. The church has intentionally avoided that in its creation of the...
Article 11E, Composition and Duties of Board of Directors. And it says, the Board of Directors is the legal representative and custodian of all the property of the Lutheran Church Missouri Synod, directly or by delegation to an agency. For purposes of this article, the Lutheran Church Missouri Synod includes both the Synod and the Missouri Corporation formed by the Synod. And then at the beginning somewhere, it points out that there's, the Synod is the corporate representative of the church, right?
Correct, Your Honor. Correct. Yeah, we don't think this is rocket science. We think that this is consistent with the church's polity.
You didn't, in fact, here it is, in the bylaws, corporate synod is not an agency.
Correct.
Lutheran Church Missouri Synod intends to acknowledge its responsibility to be subject to civil authority. In such references, however, the Synod intends to retain all authority and autonomy allowed at church. And then down right below that in definitions, property of the Synod, all assets titled or held in the name of corporate synod, its nominee or an agent. that implies that all the assets are held in the name of the corporate synod.
That's correct, Your Honor.
Okay, end of story, right?
Well, that's what we thought, Your Honor, and
That's what you thought, and that's why you introduced the declaration of Reverend Sias later on, right?
correct, Your Honor, and amended the pleadings to clarify that as well. Footnote 1 of the pleadings that directly addresses this issue, and then the Sias declaration, both of them, also address it as well. And Your Honor, also on that point, I would point you to the resolution 7-03, which is the resolution of the Synod in Convention that expressly says the Church is delegating to the President, as the Synod's ecclesiastical representative, to work ecclesiastically with Concordia, but then to the LCMS BOD, so specifically identifying LCMS's corporate board of directors to take all appropriate actions to address the situation. And so it reflects the Church's consistent position regarding its expectation that the civil law representation will be managed by LCMS and only by LCMS.
If we were to, and I'm not foreshadowing, but if we were to resolve the case on this ground that we've been discussing, do we not discuss any of the other many grounds, Rule 17 or Rule 19, and all of the Texas unincorporated, all of that? Would we stop there?
I think you would, Your
Any
Honor.
other work to be done in this case?
I don't think so, Your Honor. I think that Rule 17 and Rule 19 are off the table at this point, and so it's only the question of diversity jurisdiction on the front end, and that once you accept the LCMS's consistent position for 130 years, that the rest of it just follows. So I don't think the other arguments support that, but they're not necessary to reach to get to that point, Your Honor. Your Honor, I would reserve the balance of my time, if that's okay.
May it please the Court, Clark Richards on behalf of Appellees. The outcome of this appeal is determined by three choices made by the Synod. One was that they established a separate corporation instead of incorporating Synod for all purposes, which, if they had done so, could have established citizenship solely in Missouri for the entirety of Synod if they had wanted to. The second choice was to maintain property ownership in the Synod, and the third choice was to have LCMS sue in federal court to enforce Synod's alleged state court rights for real estate, contract, fiduciary duties, and statutory rights. Based on these three choices, the district court determined that Synod held the substantive rights, and Synod was the real party in interest and the real.
What was the first point that you had?
To establish a separate corporation and maintain Synod as its own independent entity. There's no reason why that, I mean, certainly if the church autonomy doctrine stands for anything, it is that a church may avail itself of corporate form in any way it chooses to, and could incorporate itself for all purposes under Missouri law, and therefore be, for all purposes, a citizen solely of Missouri. And if the diversity jurisdiction of the federal courts was of a paramount importance, that certainly would have been an option.
Well, it could have done that, but it chose not to do that, and I understand it chose not to do that for religious reasons, that it wanted to keep its ecclesiastical sphere not tainted by this world in which you and I occupy on a day-to-day basis, that they were keeping that world very pure for only spiritual matters. Is that not what you understood that their declaration says?
I certainly agree that the Reverend Sias, citing to older documentation and sermons, says that. The board policy manual, which has been adopted since then, seems to make clear otherwise. And so...
Okay, so they could have done that, but how is that? I don't know that that's dispositive. But you said they maintain property ownership in the Synod, and I assume you mean the ecclesiastical sphere is where you're saying they maintain property. And I thought that what the document that Judge Jones just read from said that the property was maintained by the corporate part of the Synod.
So from the Synod's bylaws, section 1.2.1 sub R, property of the Synod is all assets, real or personal, tangible or intangible, whether situated in the United States or elsewhere, titled or held in the name of corporate synod, its nominee, or an agency of the synod. So it's defining all property as belonging to the synod, regardless of who holds title to it. And an agency includes a university.
Titled in the name of the corporate synod, its nominee, or an agency. That is not, that's a description, but the title is in corporate.
Except for that the agency of synod includes a university.
Corporate is not an agency, the university is an agency. And Concordia, in its documents, specifically recognizes at least the governance, and I thought maybe the ownership of the synod or of the corporation.
There was at one time a board policy manual that did acknowledge that, Your Honor. You're correct.
Heretically, if I can use a Lutheran term, or non-Lutheran, anti-Lutheran, whatever, changed that, right?
That board policy manual was changed, Your Honor, yes. However, if I may.
Part of what the fight is over.
Well, that's what the fight on the merits will be once we have established the court of proper jurisdiction. However, I would like to point out that agency of the synod includes universities under the definition of agency of the synod. And therefore, this 1.2.1 sub R says property of the synod is assets held in the name of the university, and that's not an asset held in the name of the corporate synod or LCMS. And so it is asserting by its own governing documents the ownership interest of the real property of the university.
I'm sorry, I think the confusion is because it's using the term the synod, but the synod also refers to the corporate synod.
They are defined differently in both the pleading and in the bylaws themselves.
Talking about is the merits, and I'm talking about who is the party in interest. It will be for the judge on the merits to determine whether Concordia owns its own property, right?
Certainly, Your Honor.
Here, all we're concerned about is whether the synod is a real party in interest or a sufficient party in interest for diversity.
Absolutely. One of the reasons why it is a real party in interest and a real party in controversy for the purposes of diversity is because its own internal documents say that the property that they are seeking, as well as the pleadings also say the property they are seeking belongs to the synod.
But you need not have all interested parties as plaintiffs to litigation for diversity purposes, right?
Well, under the Humble versus Townsend decision, Your Honor.
We are not dealing with the LDS Church or its organization. We also have Watson versus Jones, for that matter, in addition to Milojevic and so on. But you only need one interested party, and if the corporate synod is a sufficiently, you would have to be able to show that the corporate synod has nothing to do with title, and my understanding of the bylaws 1.2 definition, whatever property of the synod is all assets titled and held in the name of corporate synod.
Or an agency, and an agency is the...
But that isn't relevant.
My apologies, Your Honor. There are other documents besides the bylaws that also speak to this. For example, Resolution 4-04 of the convention says the synod owns the properties of all agencies of the synod. And so this is the highest authority, their synod and convention, adopting a resolution saying that this property belongs to the synod. It doesn't say that it belongs to LCMS. Similarly, the Committee on Constitutional Matters opinion says that the university belongs to the synod, not to the LCMS. And so the documents that they have put forward saying that these establish the rights of the synod and LCMS in this case.
That's not the basis that the district court ruled on, right?
I mean, those were before the district court. I don't recall them citing to the...
The district court said the synod is an unincorporated association under Texas law, and it may hold some interest, and therefore it can be sued.
I believe this court said that, yes.
Didn't talk about does it own Concordia or not, because that's the merits, right?
But they are making the claim that the Concordia ran off or attempted to run off with a historic property of the Synod.
That's the merits.
But it is their pleadings and establishes whose interest is being asserted.
Here, diversity, it doesn't matter who it was. It can be, you know, they took my dog. And who owns the dog? Well, I used to, but now I gave it to my girlfriend, you know. As long as it's over 100,000 in controversy and they're members of diverse states.
Well,
You don't mix the merits and the question of citizenship.
well, if I can, Your Honor, I'd just like to read to you a couple of. I'm sure you're not. There are other claims being made besides the real property, such as in 52 sub F of the amended pleading. CTX and the board and the individual defendants owe fiduciary duties to the Synod as described by the Synod bylaws. So my clients are being sued for breach of fiduciary duty to the Synod. That is Synod's rights being asserted in the pleading, which certainly the court can consider the pleadings in determining who the real party in interest is. And
I don't see that.
oh, I apologize, Your Honor.
Well, I mean, again, if you know, this it's somewhere here in the Constitution or the bylaws that the Synod is a reflection. It's more than just their assertion that the ecclesiastical synod and the LCMS are reflections of each other.
I believe that's a Reverend Sias statement, Your Honor, yes.
And you disagree with that?
I don't know that I understand how the word reflection pertains to the law as it applies.
You disagree with the fundamental, I mean, what did Martin Luther say?
I apologize, Your Honor, I'm not a scholar of Martin Luther. I would say that the pleadings identify Synod and LCMS as different from each other, and the bylaws also define them as different from each other.
How do you see the declaration playing a role, if any, in one of these types of cases?
Well, what I would say is that the pleadings are more current than the historic information relied upon by the Reverend Sias. And the bylaws, Constitution, and board policy manual that are also in the record are more recent documents that the parts that we have referred the court to in terms of the rights being asserted, those are not referred to by the Reverend Sias.
He's just out of date in his understandings, and therefore we shouldn't defer to him under this doctrine? Is that what you're saying?
I believe that the constitutional avoidance doctrine would say that the court should look at the pleadings and see the claims being asserted, breach of contract on behalf of the Synod, breach of fiduciary duty on behalf of the Synod, property belonging to the Synod, that is determinative without having to reach the question, the constitutional question of the polity presented by the Reverend Sias.
Okay, your friend on the other side spends a lot of time in their brief saying that the question was pursued in exactly the backwards direction, that the district court said, can I look at this and decide this without having to get into church business? And if so, then I should do that. When actually the other side says that you should look first to say, does this implicate, how does church business deal with this? And then if so, then you have this duty to abstain. What is your theory of this question? I didn't see that this was engaged in head on. It seems that you were ships passing in the night.
The Reverend Sias does refer to the bylaws, and therefore clearly the court should look at what the Reverend Sias referred to as part of the authority, and the bylaws provide that the property is owned by the Synod, et cetera, and that they are separate entities.
Say, we we know better than Reverend Saez about what the Lutheran Church does? I mean, would the court be doing that if it were to agree with you today?
I would say that the court can look at the pleadings, and from the pleadings tell what has been asserted in the district court, and on that base can determine that the entities are separate, that the interests being asserted are civil state law claims on behalf of Synod for contract, alleged statutory violations, and fiduciary duty, and that even if the Reverend Sias is correct in that historically there has been this intent to have separation, the pleadings themselves establish, which the court should look at the pleadings, I believe, establish that the rights of Synod are being asserted here, and therefore Synod's interest is the interest that controls for determining the jurisdiction.
Why are you trying so hard to get out of federal court?
Your Honor, I have just...
Because they filed the first lawsuit and then you filed the one in state court, right?
Absolutely, Your Honor, and because my clients want this to be resolved in a court that actually has jurisdiction.
Suppose you end up in the Texas Business Court.
Oh, actually, I don't believe this is removable under the statute, but I appreciate your concern.
I thought that was interesting. Maybe this helps us in the bylaws. In the definition of terms, synod refers collectively to the association of self-governing congregations and all its agencies on national and district levels. The synod, as defined herein, is not a civil law entity.
Absolutely, Your Honor, it does say that, and a great deal of reliance is placed on that. I believe there are other documents that we can look at that contradict whether or not that means that it lacks capacity. For example, in the board policy manual of the Synod Board, 5.7.H sub 2 says the chief administrative officer shall implement administrative procedures for the corporate synod regarding legal matters consonant with board policy concerning initiation of litigation by the synod. Similarly, 4.18.3.3, no litigation proceeding shall be commenced by the synod or any of its officers, executives, or staff without prior approval of the board of directors, clearly contemplating that the synod can engage in litigation.
Not necessarily. It could contemplate that the synod has to decide that the corporate entity is going to engage in litigation, which leads me to another point, which is, if this were to stay in federal court and get resolved on the merits, how would you not get complete satisfaction in a judgment or declaration or something against the corporation?
Admittedly, Your Honor, if you decide that there is diversity jurisdiction and we are remanded to the district court for further proceedings, then we would understand that we are properly before that court and we would proceed to the merits there. And I am always concerned about whether the court has jurisdiction, which is why I think we brought a fairly straightforward request for dismissal on that basis.
Does it make a difference whether the ecclesiastical synod is a party or not?
Well, I believe under Hummel, the citizenship of the synod does control, and it is the burden, as pointed out.
Watson v. Jones held. It seems to me, I mean, I thought the Watson case from 1871 was pretty analogous.
Oh, I apologize, Your Honor. The more recent Hummel versus Townsend case was, I thought, very helpful.
Yeah, but I'm talking about a higher court.
Of course you are, and I certainly understand. The burden to establish jurisdiction is on the party asserting it, which the Chief Justice pointed out just a week ago in the Institute for Free Speech. And there has been no attempt by LCMS to establish what the citizenship of the synod is. They have said that it's not an unincorporated association.
Assuming it has to be a party, and I was asking you whether if it were not party, because we held it was sufficient for the synod to be the plaintiff here, would it make any difference to your ability to get relief? And again, I say, diversity doesn't require two entities that have an interest in whatever the plaintiff's suit is. It only requires one. so you can have mom as custodian of the minor, and you don't need dad as an additional custodian.
Certainly, Your Honor, under Rule 17, custodians can assert interest on behalf of others. I don't believe that that LCMS fits into any of those categories.
We're not communicating.
I apologize, Your Honor.
Well, that's okay. I'm sorry. I have to look into this more deeply, but basically, I do not see you making an argument based on Judge Ezra's argument, which went into all this business about neutral principles and so on.
I do believe the court can and should apply neutral principles, Your Honor.
Is that your purpose in citing Hummel then, or what?
No, Hummel is for the purposes of pointing out that a party asserting the interests of another party, that in such a case, is the parties whose interests being represented that controls for the purposes of diversity. And in that instance, it was a bishop of the Reformed LDS Church, and this court decided that it was the citizenship of the Reformed LDS Church that controlled for diversity purposes. Now, even if synod is not,
So how would you apply this to the Catholic Church?
I haven't attempted to apply this to the Catholic Church, Your Honor.
Well, we look at neutral principles, so we look at the corporate documents and the Texas Unincorporated Association statute and all that. Is there a single case in the United States that's looked to neutral principles on a matter of interpreting church governance?
Well, I believe that this is slightly different from the cases in which the court has deferred to internal. I don't have one in the federal system. In the state courts, the Texas Supreme Court frequently looks to the controlling documents of religious institutions as part of its determination of.
Well, I don't, I'm not sure I agreed with that, and we're not in state court, we're in federal court, and we're under the First Amendment and neutral principles doctrine, which the Supreme Court ordained, and those have all been property cases, right, where they look to documents which, if we get to the merits in federal court, they will look to the documents, right?
Well, I believe they will look to the documents, and I believe that the court can look at the documents now as well. I believe I'm out of time, but I'm happy to.
A case applying neutral principles to the question, who is the representative of the church for purposes of citizenship, right?
Certainly not one that I have found, Your Honor. I believe Hummel versus Townsend is the closest we have.
Okay.
Okay, but in Hummel, you agree that there was no dispute on whether that was an unincorporated association, so that doesn't get us anywhere on the district court's determination in this case.
Well, I agree that it was undisputed in that case. However, it seems clear from the documents that they pled under, they define these entities separately. The organizational documents, the governing documents, define the entities separately. So, synod exists separate from LCMS, the corporation. It must have some form of citizenship, otherwise it would be exempt from civil laws, which is not permitted under the Our Lady of Guadalupe versus Morrissey Beru. Whatever its citizenship is, must be established to determine whether diversity exists, because it's
Whether or not it's even a proper party or a necessary party has to be determined first, because it wasn't a party, and the party that holds the property is the party.
well, also the party that asserts the fiduciary rights to be litigated over, as well as the contractual rights to be litigated over. All of those are in the pleadings on behalf of the synod. Now, going back to Hummel versus Townsend, I agree that that's distinguishable in that the court there said it was undisputed it was an unincorporated association. Regardless of what form of entity it was, the court concluded that its citizenship was determinative for the purposes of diversity, and Bishop Hummel's was not.
You have to run the table on all of these arguments, don't you have to win on every single one of these all the way down? What are your paths to victory here?
I believe the court can avoid the constitutional avoidance doctrine, the interpretation of the Unincorporated Association Act, the Internal Affairs Doctrine, and all of that by merely applying the clear error review to the findings of the district court, which is that the entities are separate, the real interests belong to Synod. LCMS's interest is only by virtue of its relationship with
Yeah, that's a
with
whole
Synod.
bunch of things all at once, that they're separate, that they're the real party, that the other party, that they're an indispensable party in this lawsuit, that they're unincorporated unincorporated. You have to win on every one of those all the way down, don't you?
Not necessarily, Your Honor. I mean, if the court decides that one of the interests being asserted is synods and the others are LCMS, that would do the same thing, but the facts expressly or impliedly found by the district court in the course of determining jurisdiction are reviewed for clear error, which is the Cole versus GMC case from this court, 484 F. 3rd 717. And the court can and should, I believe, review the findings of the magistrate and of the district judge and review them for clear error, and that review should result in the conclusion that the court properly dismissed.
Can you distinguish Watson v. Jones?
I apologize, Your Honor, I didn't anticipate that. I have read it, but I have read many cases since there's been 200 and some pages of briefing.
We all. Watson had to do with, it may have been a property dispute, and a question arose whether the certain elders of the Presbyterian Church were able to represent the church. And the Supreme Court said, said yes. And they said, and I'm sure Mr. Blomberg will correct me on the details if need be, but the point is, if this is the true body of the church, the members of that congregation having rights in the building have a mode authorized by the canons of the general church. And then when it sort of allows the suit to go forward in the name of these custodians, who are like the elders, and then at the end it says, or later on, whenever questions of discipline or faith or ecclesiastical rule, custom, or law have been decided by the highest of these church judicatories to which the matter has been carried, the legal tribunals must accept such decisions as final and binding on them in the application to the case before them.
And here is my distinction of Watson v. Jones, Your Honor. That refers to internal discipline, internal faith, and internal governance. What is being requested of the court here is to decide that the external facing interrelationship with governmental bodies means that the court must adopt the synod's view and exempt it from the court's jurisdiction. And again, I think that under the Morrissey-Beru decision of the United States Supreme Court, that would mean that they are exempt from civil laws, which the Supreme Court has said they are not.
Thank you. You're entitled.
Thank you, Your Honor.
Thank you. You've saved time for rebuttal.
Thank you, Your Honor. Just a few quick points. One, you're correct. In Hummel, there was no dispute that there was an unincorporated association, so it's not probative of all of the issues before this court. Watson is directly on point because they did dispute diversity jurisdiction in that case. It was a corporation of the religious body, and at 693 and 697, you see that issue was raised. The Supreme Court exercised jurisdiction. You have a very similar type of situation here. All the relief requested for LCMS in this lawsuit is for LCMS. None of it is for Synod. If you look at paragraphs 85 and 86 of the pleadings, which is at ROA 1268 and 69, you'll see all of the things that the church is attempting to get here is attempting to get through LCMS, as you read in the provisions earlier, Chief Judge Elrod. This is a question of pure church polity. We're not dealing with the later questions that could be be involved with property matters. This is church polity, and even the Texas Supreme Court has recognized the U.S. Supreme Court's rule that pure polity matters are for the church alone to decide, and that's the Masterson case.
Even the Texas Supreme Court.
Sorry, my friend on the other side said the Texas Supreme Court said it was okay. I just wanted to emphasize the Texas Supreme Court in the Masterson decision expressly distinguished polity matters from property matters.
Can you help me figure something out?
Yes, Your Honor.
When I used to be a state judge, every single time I would be the ancillary judge, I would have a church dispute. That's emergency docket thing, and it would be usually in my own denomination, and which happens to be Baptist, and we were told it wasn't ecclesiastical, although we've seen in some of the readings that there can be ecclesiastical Baptist groups according to some of the scholars.
Correct.
But nonetheless, and it would always just be on the corporate documents as to whether the deacons could lock the pastor out and whether the pastor could be fired, and basically that was over and over again, that scenario, unfortunately, people were fighting in the courts. So what's different about that situation that makes it so clearly that that's okay for me to be looking at those bylaws and this situation?
So the key there, Your Honor, is that you are dealing with a dispute where you have two bodies both claiming we are the true church. And the state court judge, and you're right, it's normally state courts that are dealing with this particular type of dispute. The state court judge is stuck in the middle trying to figure out, how do I find a solution? That's not the situation we're facing here, where
Besides that, there's no hierarchical structure in the Baptist church, right?
very intentionally so, correct, Your Honor.
So that's why Milojevic is different from those deals.
But I put that to one side because we do have, we have several examples of the Baptist structure in the scholars of here, so.
Correct, Your Honor.
But so it was because they both disagree as to what the church's policy is.
Right, and so you have the deacons on one side and the pastor on the other, and they're both saying, hey, I'm the real Baptist church, this other person is the interloper, and the judge is stuck in the middle, and they have to decide.
You know, we did learn it in judges' school. They said, well, if it's hierarchical, if it's Catholic and Episcopal, then you do it this way, and if it's Baptist, you do it this way. But that's not 100% true according to these scholars in these writings about
Correct.
different organizations.
Correct, and you'll see also in the denominational brief that the Southern Baptist Convention participates that and through the ERLC. What you're doing is you're deferring to the type of polity that this particular religious organization has. So those Baptist churches have a polity where they are the final authority, right? There's no hierarchical authority to appeal to in that context.
It's very much part of the belief system,
Exactly, that is their doctrine.
the believer, the idea that your church stands on its own without a hierarchical.
Very much so, very much so. And that's why it's so important, Your Honor, to get these questions of how you are supposed to accept the church's understanding of its polity right, because polity differs for different religious bodies, and they're often for very important religious reasons. Your Honor,
Wrap up.
yes, thank you, Your Honor. I think the only thing I want to point to, and I saw this as I was looking through the materials, the Hosanna Tabor opinion that deals with Madison's veto of the incorporation. I think that is very probative. Madison vetoed it precisely because doing what my friends on the other side asked for, incorporating all of the church, would have transgressed Establishment Clause lines separating religious and civil spheres. And so going all the way back to the foundation of our countries, up to the Hosanna Tabor decision, you see that laid out there, and that's directly applicable here. Thank you so much for your time.
Thank you. Thank you both. Appreciate the arguments. The case is under submission. This concludes this sitting of the court.